car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis Wright.
Good evening, and thank you so much for joining us here on The Attorneys. Got a great conversation that we think will be important to you. Going to be talking about workers' compensation, what to do if you've been injured on the job, and if you're an employer out there of employees. We have a lot of information that may be of benefit to you. Again, I'm Carter Clay with the law firm of Hollis Wright. I'm here tonight with our guest, Maxwell Carter, who's going to be navigating our way through the workers' compensation laws here in the Alabama. But before we get into the topic, just some reminders on how you can get in touch with us throughout the course of the show. The show is always better if you're calling in and talking with our attorneys. We have live attorneys standing by right now to provide you with an off-air, private and free conversation to answer whatever legal questions you may have. And if we're not able to answer those questions, we will get you to an attorney that can answer those questions. You've got numbers in front of you to call. The numbers to know, though, are 844-LAW-TALK and 205-324-3600, and there are also ways to text and email, so numerous opportunities to get in touch with our attorneys here this evening. So let's jump right into it. Maxwell, thank you so much for being on the show.
Well, I certainly appreciate you having me.
Yeah, you and I have known each other for a long time. We were in law school together back at Cumberland, which is part of Samford University, back in the late 90s, isn't that right?
That's correct.
All right. Well, tell us a little bit about your law practice. I know you handle a lot of workers' compensation cases, but tell us a little bit about your background and how you got started in handling workers' compensation cases.
I've always done civil litigation work, and when I initially got into doing personal injury work, I developed a specialty, kind of a niche, so to speak, in the workers' compensation realm. I enjoyed studying it. I was a very good student at it, or so I was told. And I realized from early on that the workers in the state of Alabama need qualified attorneys to represent them in these cases, and that sort of piqued my interest.
Yeah, so you've been representing injured individuals as opposed to, I guess, defending the employer and or the workers' compensation carrier.
That is correct.
And what is it, and I want people to understand this, because a lot of times individuals are injured on the job and they think to themselves, oh, I don't want to ruffle the feathers of my employer. I don't want to run the risk of losing my job. But explain to people and make sure they understand about exactly who is the money coming from in terms of compensating somebody who's been injured on the job.
And that's a very common situation where we get into that, and I get to ask that question often of, hey, I don't want to muddy the waters with my boss. As I explain to people, you are not dealing with your company, unless it's a large company that is self-insured. You're dealing not with your boss or your boss's boss or even your coworkers. You are dealing with an insurance company, a third party that doesn't know you, doesn't know anything about you, generally knows very little about what the business is about. So it's a very almost cold type of relationship, and the employer is oftentimes taken completely out of the loop of the insurance claim process.
Yeah, and no different than if you've got automobile insurance or homeowners insurance and somebody makes a claim against you, the employer in a workers' comp situation is going to turn that matter over to the workers' compensation insurance company, and they pretty much, I guess, effectively kind of remove themselves from the equation, and you're pretty much dealing directly with the insurance company at that point.
About 98% of the time, that is correct.
Okay. In terms of somebody getting injured on the job, obviously they need to take care of their medical needs first, but in terms of preserving their workers' compensation claim, what are some of the things that they need to be thinking of doing immediately from the outset?
From the outset, the first and foremost thing that an injured worker needs to do, if it's not an emergent situation, is report all injuries. that is the touchstone for being able to track the date of injury back to exactly when I was hurt. Was I actually hurt on the job? Did it arise out of the job, and was it in the course of my job? Where was I when it happened, and was I where I was supposed to be at the time? So you want to report everything. That I'm not talking about a paper cut. I'm talking about if somebody is even moderately hurt, report it. And then that triggers notice to the employer, which is a requirement under the Act for coverage to kick in, because if an injured worker does not notify their employer of an on-the-job incident or injury, and then months later comes back and wants to report that incident, that gap in time causes very, very difficult causation problems.
And I think, are there not time limits in terms of when you're supposed to notify your employer that you've experienced an on-the-job injury?
There are. The Code of Alabama actually says you're supposed to, if possible, notify the employer within 5 days. Obviously, for various reasons, some injured workers are hospitalized, or they just don't realize the extent, and they're just not physically able to do so. And then there's a second fallback provision in the code that says, well, if you can't do it within 5 days, it needs to be within 90 days. And generally, an injured worker would be able to have that report or have that discussion with the employer or the workers' comp carrier within that period of time. And there are some other savings provisions in the Act that say a reasonable period of time.
Yeah, and I've handled a lot of workers' compensation cases myself over the years, and one of the injuries that I see this happen most often in is, say, like a back injury, where obviously if you break your arm or your leg on the job, the employer's probably going to get notification of that. But a lot of times, if you've got like a low back injury where your back just starts hurting and you can't pinpoint the actual time that it got hurt, but you know that it was hurt from lifting objects on your job, sometimes they don't report that or notify that employer, and that can cause a lot of problems down the stretch.
It absolutely can, and those sorts of situations, as soon as somebody realizes, hey, I've got a problem, this isn't just a back strain that I hope would go away within a few days, but I know I did it at work because I don't do other things that would cause this sort of pain. As soon as the injured worker makes that connection, they need to immediately report it. They need to report it to their supervisor, they need to report it to HR, or if they work in a facility that has medical offices within the facility, go report it there. If it's a union shop, report it to your union steward. And give a best time frame, best estimate as to when I think this problem started.
Okay. It's a great time to take our first break of the evening here with Maxwell Carter talking about workers' compensation. And just again, as a reminder, give us a call throughout the show. We've got lawyers standing by right now to talk with you and answer your legal questions. Stay tuned. We'll be right back for more of The Attorneys. I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was We would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the attorneys.
Welcome back into the Attorneys here with Maxwell Carter covering workers' compensation. Maxwell, let's jump right back into the topic. Talk a little bit about the system that is set up here in Alabama. A lot of times when we talk about car wrecks or slip and falls or medical malpractice, it goes without saying that we have to prove that somebody else did something wrong that caused our injury, but the workers' compensation laws are different in that regard. Is that right?
That's correct. When the initial Workers' Comp Act was designed, there was a trade-off to where employers said, we understand we have employees that are getting hurt on the job. However, we're being sued by these employees for fault-based type of liability. The trade-off is that if the law that is brought into place will give us immunities from those, we will create a no-fault system, which means as the injured worker, I don't have to prove that somebody else on the job hurt me. I don't have to prove that my employer did anything wrong. All I have to prove is that I was at work doing my job, how I was supposed to be doing it, where I was supposed to be doing it, and that an accident happened and I got hurt on the job. It's a no-fault, true no-fault system.
What happens if the injured person was at fault for causing their own injury? Do they still get benefits, and do you find that people are reluctant to notify their employer of an on-the-job injury if they think that they did something wrong?
Oftentimes that is the case. However, as I tell clients all the time, accidents happen. And in particular in commercial settings and in industrial settings, machines break, people fall off of platforms. It's just a fact of life, and injuries on the job are just going to happen. The injured worker's fault, a co-employee's fault, nobody's fault. And so that's part and parcel of the no-fault system. So employees, if they are hurt in the line and scope of their employment, and it arose out of that job, and we can get into that later, what those two terms mean, and they're very specific. But if those two items are met, then by and large, they've met the burden of proof to institute and be deserving of their workers' compensation.
Yeah. Now, just like, as you know, with just about every law that's out there, there are always exceptions to the general rule, and we've talked about a no-fault based system, but are there circumstances in which a fault can come into play that could cause an individual to lose their benefits, and if so, what are some examples?
There's three primary examples, and there are more than three, but the top three that right off the bat come to mind are where people may be at work, and I have an example. Two guys were in the shop, and they were working, and then they were horse playing. One started wrestling the other, and they were going to see who was the strongest, and then somebody ends up hurting their back. That's known as willful misconduct. The company didn't hire you to wrestle on the factory floor, but y'all were doing it anyways. That's intentional willful misconduct. The second way is voluntary intoxication. Somebody just shows up to work drunk, or under the influence of drugs or some other substance that just makes it to where they're not going to be able to safely work, and then they end up injured on that job or that facility. And then the third way, and this happens, it happens rarely, but it does happen. I've seen it happen, where somebody will go to work and think that there is some monetary benefit to them if they intentionally injure themselves and try and pin it on the employer.
You've seen this happen before?
I have seen this happen with egregious results in a young man who was injured horribly, but his design going in was not nearly as elaborate, and he suffered a very, very serious injury. That was the comp claim was denied for that reason, because the employer was able to prove he set out with intent to injure himself.
Wow. Let's talk about physicians. If you're injured on the job, do you get to just go see your own regular primary care physician, or are there other physicians that you have to go see?
The code sets aside the parameters for who gets to pick and choose doctors. And part of the trade-off with the no-fault system is the employer is allowed to choose the medical provider, and that medical provider is the one that dictates the treatment. And they are known as an authorized treating physician. This is the doctor that steers the ship, so to speak. They make the calls as to what treatments to have, what surgeries, if the injured worker needs to be referred to another specialist. It all ropes back around to the authorized treating physician. Only in very, very limited circumstances, in very unusual circumstances, will an employee be allowed to go choose their own doctor.
Yeah, I've heard references before to a panel of 4. Well, what is a panel of 4 in the workers' compensation context?
In the workers' compensation context, if the injured worker is dissatisfied with the authorized treating physician's choice of treatments, or just dissatisfied with their care or their bedside manner or whatever that they don't like, they have a one-shot option to change doctors within the system. So what we would do is, at that point, the injured worker or their attorney would contact the workers' compensation insurance carrier and say, my client is dissatisfied, we want to get a panel of four other physicians that are certified in the same type of medical field, and we get to choose from that panel. Now, the kicker is the employer provides the doctors on the panel.
Yeah.
We don't get to select them.
Yeah.
But once you choose that doctor, you are essentially that doctor's patient. So choose your panel wisely.
That's right. Well, it's a great time for our last break of the evening. Stay tuned for more of the attorneys coming right up. And remember, you can always find Hollis Wright on just about any social media platform out there, Twitter, Instagram, or Facebook. Hit us up on one of those social media platforms throughout the course of the week. Like and follow us. There's lots of information for you. Stay tuned. Coming right back. I'm Josh Wright with the law firm of Hollis Wright. As with any industry, it's important in the legal world to hire an attorney that is knowledgeable and has a track record of success. But with so many attorneys out there and so many different types of cases, how does someone decide the right lawyer to hire? In this week's Legal 4-in-1, we're answering the question, what should I consider in hiring an attorney? In-state versus out-of-state, big firm or little firm, recommendations from friends or family, the internet, the phone book, or TV. With so many choices and so much information, it can be an overwhelming task trying to make the right decision. To complicate things, choosing a lawyer is an important and sometimes life-affecting decision and should not be taken lightly. So how do you select an attorney? First, do your research. Look the firm up on the internet. Learn about the cases they handle and the results they get. Second, find out what clients are saying about the firm.
Many websites provide client testimonials or have a star ranking system. Use those to your advantage. And finally, talk with a lawyer from their office and ask them questions. Questions about the volume of cases they handle. Do they return phone calls? Are you just a number or a client that gets the attention you deserve? Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a confident lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys right here on WVTM 13.
Welcome back into The Attorneys here for our final segment of the evening. This show has flown by. We've been diving into workers' compensation with Maxwell Carter, and again, just a few minutes remaining, so get those questions in if you've got questions. Max, let's talk a little bit about the different types of injuries that you see in your practice and the classifications for those injuries under the Alabama Workers' Compensation Act, because impulsively you think, oh, well, an injury is an injury. That's pretty easy to discern, but there are a lot of different classifications and different types of injuries. Is that correct?
That's correct. The word accident actually has a definition in the Code of Alabama, but within that definition of what qualifies as an accident, there are subcategories of it. The first one and most obvious to people would be the traumatic injury. The injury where somebody's working in a factory and their hand gets broken in a machine. I'm lifting a box and twisting and I hear a pop in my back. Those sorts of traumatic injuries, I call them the ouch moment. It's something where you can point definitively to an instance or an event that is unquestionably the source of that injury. The second under the accidental injury would be under the definition of injury would be the non-accidental injury, where you have a worker that may suffer on the job a heart attack or a stroke. And in certain instances, those can be compensable.
But they're harder to prove.
They are harder to prove. And the key to that is did the job expose the injured worker to some sort of causative factor that the average person in their everyday life would not generally be exposed to. For example, I had a tractor-trailer truck driver at one point that was working in extreme heat over in Mississippi, and after tarping his load, he suffered a heart attack. Extreme heat, extreme cold, things of that nature that put a lot of stress on the human body that generally people would not experience. And those are the
What about
first
like
two.
cumulative trauma or exposure type cases?
Well, in cumulative trauma, which the classic, as we know, is carpal tunnel syndrome, repetitive stress injuries. Those are compensable. They need to be reported, as all injuries do. They need to be reported as soon as the injured worker realizes that, hey, my one hand or both of my hands are hurting. I am not doing anything elsewhere that would cause this other than working in this plant or this factory or whatever. They need to report it. And yes, they are compensable. There is a higher burden of proof on the employee, medically speaking, to prove that cumulative trauma injuries are caused by clear and convincing evidence. And that is evidence that generally no two people looking at it could disagree as to the cause.
We've got a viewer question here that I want to cover because I think it's a really pertinent question. I was recently injured on the job. I'm getting medical treatment, but I am not able to work. Am I going to be able to get paid while I am off work?
You generally should. And the rule of thumb is I want to mention one thing to your viewers. First of all, your personal physician cannot take you off of work in a work-related injury incident and the employer or their compensation carrier be required to pay you based on your doctor's excuse. The way that they will be paid, the injured worker will be paid, is two different ways. One is if the authorized treating physician says, no work at all. I don't want you going back to that job until your recuperation is complete. And the second way is if the authorized treating physician says, you can go back to work, but under certain circumstances, restrictions, such as only seated work, no lifting more than 10 pounds, no walking, no ladder climbing, things of that nature. And the injured worker takes that back to the employer and says, here, I'm cleared to come back to work, but these are the restrictions. And oftentimes, in particular in industrial settings, the injured worker, the employer will say, we don't have light duty here. We don't have anything that would fall within these restrictions, so they can send the injured worker home as well. So it's a two-part system, but in those instances, they would be compensated.
Yeah, and they're going to get 2/3 of their average weekly wage, is that right?
That's correct, for that period of time until they're capable of going back to work.
Just a little over a minute left in the show. Just wanted you to provide the viewers with some final thoughts, sort of the final charge of what you would like for them to take away and remember most from this evening's show about workers' compensation.
First and foremost, report injuries. Reporting of injuries is extremely paramount to being covered. I can't stress how important it is. I have had too many clients come back to me and say, I just didn't tell them, and now it's been too long, and they are accusing me of having gotten hurt somewhere else. Yeah. A second factor would be
Talk about 15% fee.
the 15%
Yeah, that's a
fee,
good
how you pay an attorney,
Yeah.
and should you consult with an attorney. The 15% fee,
And just to make sure, it's only, because we're running short on time, don't want to interrupt you, but it's only on what the lawyer recovers for you outside the 2/3 average weekly wage for permanent injury.
that's correct, and it is contingent on the attorney getting you benefits that you otherwise would not be entitled to.
Thank you so much for watching the show. We're just about out of time. See you next time.
Thanks for watching The Attorneys, sponsored by Hollis Wright.